So members, our last bill up today is House File 312, Court-Appointed Counsel Requirement in Child Protection Cases Modified. This is Chair Becker-Finn's bill, and Chair Becker-Finn, would you like to move your bill?
Yes, I would move that House File 312 be recommended to be re-referred to Human Services, Finance, and Policy Committee.
Thank you. And I do understand that you have an author's amendment. Is that correct?
Yes, thank you, Madam Chair. It is the A1 amendment. It essentially just gets the bill in the shape that I would like and gets it more in line with current practice.
All right, so we will move to a voice vote on adopting the A1, but just to take a minute here and see if there are any questions regarding that amendment. All right, seeing none, no questions or discussion on adopting the A1 author's amendment. All those in favor, please unmute and say aye.
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 Opposed? The A1 amendment is adopted. And Chair Becker-Finn, please tell us about your bill.
Thank you, Madam Chair. So House File 312 is regarding representation of parents or guardians in child protection proceedings. So right now in child protection cases, there is no guaranteed right to counsel for parents and guardians. Current statutory language is permissive. Counsel shall be appointed, but only if the judge feels that such an appointment is appropriate. And so there's a lot of sort of leeway there that's given to the judge. This bill addresses that by requiring that the court appoint counsel if the parent wants counsel and if they qualify financially. It's essentially the same qualification that one would need to qualify for a public defender. The heart of this bill really is that families should be together. Of course, safety is paramount in child protection cases, but these cases are often messy and the best course of action is not always clear. And we know that separating children from their parents is traumatic for the children and the parents and the rest of the family, and that this can have reverberations really for generations in a family. For any of us who are parents, I don't know that there's anything more core to a thing that I know that is true than that I would do anything for my kids. And so that's really the heart of this bill. The separation of children from their families via the child welfare system has historically disproportionately impacted children from BIPOC families as well as low-income households. The color of your skin or the amount of money you have should influence the outcome in these cases. In order to reduce unnecessary removals of children from their parents, we should all support a balanced system where each party is represented by counsel. And this will result in better results because all sides will be represented by trained professionals. I know this will cost money, and I'm working with DHS and other stakeholders to make sure we are doing this in the way that is most economically feasible and sustainable. But those financial implications will be addressed more thoroughly in the Human Services Committee, since that is where that is the budget that would be impacted. And before we even get to any questions about it, there's also concern about finding the necessary attorneys to represent these parents. With technology now in place post-pandemic, we know that we are capable of much more from a distance than we used to think possible. The effective date isn't until mid-2022, and we'll continue to work with stakeholders to make sure that this can become a reality. 41 other states throughout the country have figured out the logistics, and I'm sure that if we commit to this, that we can also figure it out here in Minnesota. Minnesota is one of only 8 states that does not provide a right to counsel in these cases, and we need to do better. And I do have several testifiers, Madam Chair, and I would like to turn it over to them.
All right, thank you, Chair Becker-Finn. Is Joanna Woolman testifying, or is she just available for questions?
Thank you, Madam Chair. She's just available for questions. We really want to get to Ms. Wade and some of the other testifiers.
All right, very well. Ms. Wade, if you can introduce yourself and begin your testimony. Welcome to the committee.
Good morning, Madam Chair, and thank you so much. Appreciate it. And committee members. Can you hear me? Good? Am I okay? Okay. My name is Lorene Randall Wade. I am the executive director for an organization called Minnesota One Stop for Communities, where we provide parent mentors to parents who have children in out-of-home placement, and the parent mentors are able to help parents navigate the child protection system to be reunified with their family. One of the things I know, as long as I've been doing this work, and it's been since quite some time, since 2012, since I've been doing this work, parents who appear at court because they have a child protection case who do not have an attorney present with them find themselves really lost. The system is already scary enough. And when they do not have representation there, they don't know what to say. They don't know what not to say. They don't know what questions to ask, or they don't know the direction in which to go. I often talk to parents who don't have that representation at the first hearing to kind of calm their nerves and begin to ask questions to the right people about can they receive representation, and if so, when can they get some? When can someone call them or consult with them? Child protection court is almost like you are guilty, period. You don't get to prove that you're innocent. You're just guilty based on the report that was screened in and the children being removed from home. You're guilty and you don't get a chance to prove your innocence. And it's different from our criminal court, where in criminal court, there is an attorney there with the individual that's been accused of a crime. There is such grave importance in this process. And I believe a lot of children can be returned home quicker if there was representation at the onset when the parent has to enter into court for various different reasons. Sometimes children can go home right away. Sometimes children stay in the system longer than what they should stay in the system because parents lack the knowledge and the resource to have someone there advocating for them on their behalf. And effective representation at that, someone that knows the child protection laws, the statutes, and are able to challenge what the statute is, because all parents don't fall under the same statute. Whereas sometimes in this state, when parents receive child protection cases, they kind of apply all statutes to all parents, no matter what they are. And it's not fair to the parent. It's not fair to the children. It's not fair to the family. So I am all for parents having effective representation at the onset, because I see a lot of our parents suffer in the beginning without that, especially parents in rural counties that don't have access, and an attorney has to come away from another county to provide this representation for them. They miss out on a lot, and the clock is ticking. Once a court date is the EPC hearing happens, the clock is ticking, and it doesn't stop because parents don't have that attorney with them at that very first hearing. The clock continues to tick, and time continues to pass by. So I think parents have suffered, and we don't want that for our families anymore. So I approve of this bill going forward. And I hope that others would approve of this bill going forward for the betterment of our community, for the betterment of our parents, for the betterment of the children and the family as a whole. And with that, I say thank you for your time.
Thank you so much, Ms. Wade. Thank you for your testimony. And I believe the next testifier is October Allen. So Ms. Allen, welcome to the committee. Please introduce yourself and you can begin.
Thank you so much, Vice Chair Mueller. My name is October Allen. And my testimony has to do with my lived experience. So at the age of 12, I was placed into foster care. I grew up in an Indian reservation in Cass Lake, Minnesota. And it's like Lorraine said, it was very rural, not many resources, services, or supports. I went into foster care and I bounced from foster home to foster home to foster home, and then later entered into the juvenile justice system. I never went back home. As an adult, I asked my mother, Mom, why didn't I get to go back home? And she said, I didn't know that you could. She never knew that she could. And I don't know that she ever had anyone to stand with her or walk her through the scary process that she had entered. Years later, I found myself with my own child protection case. Was there an attorney there to meet me? No, I don't remember that. But what I do remember is I remember sitting there all alone, scared to death, not knowing where my children were, not even realizing what had happened, and really needing help or somebody to speak to me and to tell me the next steps that needed to be taken. It was a long journey and a long process, but I did eventually earn my children back. It was a long road, and I learned a lot of lessons, and I found the courage and the ability to communicate my needs all on my own, to where when I was finally reunified with my children, the judge nominated me to a parent mentor program. And he said, I have never seen anyone in 40 years do what you have just done. Will you help other parents? So I have been working with parents for Minnesota One Stop for Communities for 5 years. And I don't see any of them ever having a court-appointed attorney at that first hearing. But we are there. We are there to see the impact that it would make to have counsel appointed at that first hearing. We are there to soften the blow of the trauma that is endured when these parents enter that courtroom. And Representative Becker-Finn spoke to, do they qualify? Do they want it? Absolutely. The majority of the parents do qualify, they do want it. And my question is, do they need it? And the answer is yes, they absolutely need it for the betterment of our communities, the safety of our children. And I remember in one of my trainings, I can't quote the senator that spoke to it, but he prided himself in the work that he had done in the child welfare system. And there was a boy that had entered the system and did very well. And at the age of 18, when he graduated out of foster care, the senator asked him, out of all that we have done for you in this system, is there anything more that we could have done? And the child said, you could have went back and helped my mom, because he never got to go home. And so as I stand here today, you guys, actually, as I sit here today, I just am a huge advocate, and I just want to give a voice to those parents that sit there all alone. And I also speak to my mom's experience. I wish there would have been somebody there, because I did grow up to become somebody. And I just really wish somebody would have been there for her. And with that, I thank you for today and all the good work that you guys do. Thank you so much.
Thank you, Ms. Allen. And you mentioned the word courage, and we appreciate your courage in coming to the committee today and sharing your story and experience with us. So thank you. Chair Becker-Finn, I believe your next testifier is Wanda Giermann. All right, Ms. Giermann, welcome to the committee. Please introduce yourself and you can begin.
Thank you, Vice Chair Moeller. My name is Wanda Giermann, and I am a child protection attorney in Minnesota. I am a court-appointed attorney in 3 separate counties in more of the rural areas of Minnesota. And I'm here to tell you a little bit about the differences that I have seen with child protection throughout the years that I've been practicing, specifically with respect to parent attorneys and the differences that I feel we make when we are appointed early on in a case versus later on in a case. I have worked in counties where there isn't a child protection attorney early on in the case, and I've also worked in counties where I've advocated for the county to contract with us to appear not only just one attorney, but an attorney for each parent that appears in child protection cases at the emergency protective care hearing. And I see the differences that it makes with respect to these parents and their ability to successfully work their case plan and be reunified with their children. Some of the benefits are early on when working with the parents, an attorney is able to, first of all, start building trust with our clients, where we can then further assist them throughout the entire process. Child protection timelines in Minnesota are very quick. Once a child is removed from a parent's care, their case has to be reviewed within 180 days to determine whether or not the petitioner should move to permanency, which could include termination of their parental rights. And so 6 months is a very short period of time to address any issues in which the parents might have that might need to be addressed. When there's a child protection attorney appointed early on, we can explain to the parent that this isn't a criminal case, that they're not being charged with anything, so to speak, that oftentimes some of the concepts that they might hear, whether it's because they have a friend that's been charged with a crime or on TV where they shouldn't provide statements, they should not cooperate, that it's different in child protection. And oftentimes it helps to talk with a social worker, discuss the issues that you're having, what you could use help with, what they can do in terms of providing services to you, and also explain to them that child protection case isn't just about what's required out of the parent, but it's also about what's required from the county and what services the county can provide them to help remedy whatever situation they're struggling with or that they might have. We can, early on in the case, talk about measures that a parent can take to bring a child home sooner, such as safety plans, assessments that might be needed for mental health and chemical dependency. And if that's not done at the very early stage of the proceeding, the emergency protective care hearing, up to 10 days can pass, and sometimes longer, where that's valuable time for a parent to be able to get in, get an assessment, develop a safety plan with the county, where the child could potentially be returned home sooner. There's also some very important arguments that are made at the first court hearing that a parent faces in child protection. At the emergency protective care hearing, it's basically a hearing where the parent is made aware of why they're being brought before the court, what their rights are with respect to a child protection case, and then the court makes certain findings, one of them being whether or not the child would be immediately endangered if returned home to the care of their parent. And this is ultimately one of the most traumatic type of experiences that a parent can go through, and for them to have to go through that alone and rely on whatever information or knowledge they might have about the system. I can't imagine being in that position, and having an attorney that's there that can tell the court the information that the court needs to know so that the court can make the best decision on something that is going to really impact the case going forward, whether the child can return home or not, is absolutely essential in my opinion. And so I'm hoping that this bill would be approved. I guess I'm here to answer any questions that anyone might have with respect to the differences that I see in terms of when I haven't been appointed early on in a case and when I'm appointed from the beginning. Thank you.
Thank you so much, Ms. Giermann, for your testimony. We appreciate it. And I do note that there are several members with questions. I believe that Chair Becker-Finn has a number of other testifiers on standby to help with questions. And we have one more testifier from the public before we get to your questions, and that is Carly Stark. So welcome to the committee, Ms. Stark. Please introduce yourself and you may begin.
Thank you, Madam Chair and members of the committee. My name is Carly Stark. I am a policy analyst with the Association of Minnesota Counties. For those new members, AMC represents all 87 counties. We are a voluntary association. So I want to start by saying that we recognize the importance of this bill. We recognize the importance of parents having counsel. In 2008, the Public Defender's Office was unable to continue providing that service due to finances. And then that service of providing parent representation was then shifted to the counties without funding. So I think that's good context to understand going forward with this. And also that in many counties, representation is already being provided, but there is a gap with that first hearing, which is generally the emergency protective care hearing. I also want to start by thanking Mitchell Hamlin Institute to Transform Child Protection. They have done a lot of work on this bill, and they have included us in that work to help alleviate the concerns of counties. So I'll quickly touch on the financial issue, even though I know that's not in this committee. As I said, counties provide representation in most cases, and there is no state funding for that when originally it was all funded by the state through the state, Public Defender's Office. We appreciate that there is an appropriation in this, and we urge you to recognize the importance of state support of this issue. You know, the counties do a lot of services, and I think the state also needs to recognize the importance of this. Another thing to point out is that I know some testifiers may talk about 4E funding, which is federal funding, and these representation costs are reimbursable through 4E, but there have been some implementation issues with 4E where counties are not necessarily receiving that reimbursement. So I just want to put that out there. Our concerns for this committee have to do with implementation and liability. In Greater Minnesota, there is a limited attorney workforce that is able to join child protection attorney rosters. There are attorneys that are on multiple rosters and must travel a long way on short notice. Especially for the first hearing, it happens within 72 hours of when a child is removed from the home. So court administration has to get an application for an attorney from the parent and ensure that an attorney gets there on time for the hearing. We understand that virtual court hearings are increasing. Even though it's always better to be in person, those could alleviate some of these issues. However, the counties do not have control over those policies. It is the judicial branch that has control over those policies. So we hope that those are expanded to help with these issues, but we're not in control of that. We want to ensure that if this bill goes through, that it does not lead to actual delays in permanency because an attorney can't be at the first hearing, because there are multiple ways a judge can continue hearings for good cause. And we want to make sure that the good cause of not having an attorney doesn't delay the hearing and ultimately delay reunification of the family. So the last issue is the liability. Even if counties do everything that they can, it may not be possible in some cases to get an attorney to the emergency protective care hearing due to those issues that I mentioned: distance, attorney availability, or even parents not being able to fill out the application quickly enough. We worry that counties could face legal liability in those cases despite putting in a good faith effort to appoint counsel at the first hearing. We're not saying that attorneys shouldn't be appointed and that counties shouldn't try. However, sometimes it may not happen, and we want to ensure that counties are protected, because when counties are sued and have to pay settlement or increase insurance costs, that takes money away from things like human services and the services that these parents and children need to stay unified. Additionally, local court administration plays a large part in facilitating the appointment of counsels. In many counties, the county pays for and creates the roster of attorneys, but the judicial branch is in charge of the policies and procedures regarding actual appointment of counsels or counsel. The county does not have control over those policies and procedures, despite being the legal entity liable for not providing counsel. Now, the court administration does a great job in a lot of places, but there's just that disconnect between the county who hires the attorney and court administration who has the policies and procedures to make sure that they get appointed. We think this bill has the potential to help parents and create change, but only if implemented and funded properly. We look forward to working with Chair Becker-Finn and the Institute to Transform Child Protection on this bill going forward. And I will stick around for questions. Thank you so much for your time.
Thank you, Ms. Stark. We appreciate it. Members, it looks like we have 6 questions, and we do have to stop at 9:55 for a vote, but I think that gives us time for discussion, and I will call on Representative Novotny first. Representative Novotny.
Thank you, Chair Moeller. Originally had a question that I was going to ask, but it was very eloquently answered by testifier Allen, and I just want to reach out to her and say thank you for your testimony. It was very moving, and thank you for getting on your feet and giving back to the community. You're an example of what everyone should be or should strive for. So moving on, I'll just make a quick statement. I just feel it's very important that the people that are doing this are trained. I believe there was a requirement, but it's been removed, that we have specific training for that. I think that should be a guardrail that we put in place. Thank you.
Thank you, Representative Novotny. Chair Becker-Finn, did you want to address that last piece?
Yeah, just real quick. Thank you, Madam Chair. So current practice, I mean, attorneys are still receiving training. It's just what we amended out was 18 CLE hours, which is actually a lot of CLE hours. And especially if we're trying to make it easier for more attorneys to jump in and get on this roster. Obviously, we want folks to be trained. It's just the 18 hours is quite a big lift, and we want to make sure that we're being a little more streamlined in our training. But noted. So thank you for your comment, Representative Novotny.
All right, Representative Feist.
Thank you, Madam Chair. I just wanted to comment that I am so strongly in support of this bill. I have a very good friend who went through this experience and could not afford an attorney to help him with a child protective services situation with his son. And I saw how hard it was, even for somebody who is relatively sophisticated to, as a parent, there is nothing, as Chair Becker-Finn said, there is nothing more awful than not having control over the well-being of your child. And so I just think having a dispassionate, skilled attorney is absolutely essential. And I've seen just secondhand over the past year, just how the situation is drawn out and made more complicated and than it needs to be, and how that has really been negative for the child's well-being as well as the parent. So I just strongly, strongly support this bill. Thank you.
Thank you, Representative Feist. Representative Scott.
Thank you, Madam Chair. And I just wanted to say, I love the concept of this bill. My concerns have already been stated. In fact, the chair stated some of them is just the shortage of attorneys. We don't have enough attorneys to do be public defenders and legal aid attorneys. These people are just in short supply. And then the other concern, of course, is the cost to the counties. And I'm wondering, Chair Becker-Finn, if you've requested a fiscal note for this, and obviously it would be a local impact fiscal note. And I know a lot of counties are doing this. I was just texting with a friend that just went through this process with her niece, and she was trying to remember back. It was a Ramsey County case, and she believes that the mother was given a court-appointed attorney right away, but that's not always the case. So there's some of those just logistical things, and if we could clone more attorneys that would be willing to do this work, that would be awesome. So I just wanted Chair Becker-Finn's just reaction to those comments.
Chair Becker-Finn.
Yeah, thank you, Chair Moeller. So first, I want to just clarify that the problem is not that we don't have enough public defenders and legal aid attorneys. It's that we don't pay them enough so that it's a choice that folks with law school debt are making. I can personally say there are plenty of people that I graduated with. We have 3 law schools. We used to have 4. We have 3 law schools in Minnesota. We're turning out plenty of graduates. It's just we don't pay folks enough. And so it's not economically feasible for a lot of folks, even if they would prefer to do this kind of public service work. So part of the expense of the bill, we have requested a fiscal note. I've been in touch with DHS to make sure we have ongoing conversations to make sure that we are, that the fiscal note is as accurate as it can be. Acknowledge that there is some local cost, but the cost of this bill is actually that the state would be paying for this. There is also, and not to spend way too much time on the financial piece, but there's also the opportunity for public funding or federal funding through 4E funds, which is something that changed in 2018. So that's a relatively new option available for these types of proceedings.
Follow-up, Representative Scott?
No, thank you, Madam Chair.
All right, next up is Representative Frazier.
Thank you, Madam Chair. I recall when I was a public defender before they made the switch to counties paying for this, representing clients in CHIPS cases, and I recall how those cases went differently because they had representation at the beginning. How much hope that the individual, that the parent had, because they had a lawyer that could help them work through the system, and they had confidence in that. They also felt that the system was more fair because it provided them with that representation. I think about when I think about, or I hear us discuss the costs, what I think we have to think about is the cost to society when we don't provide this type of representation within a system that many folks that are being impacted don't have familiarity with. They don't know how to represent themselves, and it's created huge inequities within our society. And so we have to think about that cost. I'm 1,000% behind this bill to help alleviate some of those inequities. And I just think we always need to keep that in mind when we're thinking about passing legislation. Will it cure an inequity? Will it stop exacerbating inequities that we have? And I think this bill will help do that.
Thank you, Representative Frazier. Representative Liebling.
Well, thank you, Madam Chair, and thank you, Representative Becker-Finn, for bringing this bill. I so am behind the principle of this and the need for it. The reason I raised my hand, however, is I do have some heartburn about the funding in the bill, that you're putting this in the Human Services budget. And I really think we need to just, obviously this is not a simple funding issue. And I think there's just, I certainly am going to vote for the bill, but I wanted to say that by doing so, I'm not giving the yes, we can to the funding source, because, I really think there's some concern there. And Ms. Stark discussed some of this and kind of highlighted how many issues there are to unpack. So I really hope that we can do some work, and looking forward to seeing what the fiscal note is. But I really would love to at least get started on this, because I really do feel like this is such a huge equity issue. It's such a huge issue about our kids and our future. And, you started out saying, Chair Becker-Finn, about, how it's traumatizing for kids to be separated from their parents. And it should never happen unless it's absolutely necessary. And this is one way to help that. So it has so many great impacts, a bill like this, but I just really want to be cautious about how we put the funding together. Thank you.
Thank you, Representative Liebling. Chair Becker-Finn, did you have a comment?
Yeah, thank you, Chair Moeller. And I guess I encourage members to, instead of saying, this is great, but that we start thinking about it as far as, this is great, and we need to figure out how to fund this. And, we're still working on that. We're still having those conversations, but we thought it was important to sort of get this committee getting things going and really raising the conversation, so folks are thinking about why it's important that we figure out that funding piece, because this just is this is one of those issues where I think we need to push ourselves to figure out how to do it. And I've never been one to shy away from taking on bills that are difficult, but I think that this one is incredibly important. And I do want to just point out too that some counties are already doing this and are already paying for that, and that's great. And what we want to make sure is that no matter what county a child and a parent live in, that they would have access to that same type of assistance through having counsel. And finally, since I don't see any other hands, I'll just say that our current system favors solid, permanent answers. And that makes sense because we want there to be stability for children. But we also need to make sure then that the rights of parents are being fully heard from the outset, because this is a permanent thing. And this bill specifically, in the types of cases we're talking about, it's CHIPS cases, but it's also termination of parental rights. And I can tell folks just from anecdotally from the people I know who have faced these kinds of hearings that once your parental rights are terminated, that is it. And that is really heartbreaking to think that a parent's rights could be terminated when they didn't even understand what was happening or how the system was working and what that means. And so I think, it's about the rights of parents, but it is also about what's best for kids. And as we heard in the testimonies, especially from Ms. Allen, kids always want to go home. you know, your parents are always your parents. And so I think that that's, you know, we don't want to be unnecessarily separating children from their parents. And that's really what this is about, in making sure that all sides are properly heard in these kinds of cases. So I thank you, members, for your questions and the testifiers for the really moving testimony. So thank you.
Thank you, Chair Bickerfin. And I don't see any other member questions. So with that, Representative Bickerfin renews her motion that House File 312 as amended be recommended to be re-referred to the Human Services Finance and Policy Committee, and the clerk will take the roll.
Chair Bickerfin.
Aye.
Representative Moeller.
Aye.
Representative Scott.
Aye.
Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossel.
Too much work to be done on this, Madam Chair. I got to be a no. There's too much work to be done on this before you move it forward.
Representative Herr. Excused. Representative Hollins.
Aye.
Representative Johnson.
No.
Representative Liebling.
Aye.
Representative Long.
Aye.
Representative Mortensen.
No.
Representative Novotny. Representative Novotny, aye. Representative Farr.
No.
Representative Robbins.
Sorry, aye.
Representative Vang.
Aye.
Representative Zhang.
Aye.
Okay. I have 12 ayes and 4 nays.
There being 12 ayes and 4 nays, the motion prevails. House File 312 as amended is recommended to be re-referred to the Human Services Finance and Policy Committee. And I am virtually tapping the gavel and handing the gavel back over to Chair Bickerfin.